Ready? Exercise number 101, legal matter, start. A criminal court fastening vicarious liability must itself as to the prior meeting of the minds of the principal culprit and his companions who are sought to be constructively made liable in respect of every act committed by the former. There is no law to our knowledge which lays down that a person accompanying the principal culprit shares his intention in respect of every act which the latter might eventually commit. The existence or otherwise of the common intention depends upon the facts and circumstances of each case. Stop, next para. The intention of the principal offender and his companions to deal with any person who might intervene to stop the quarrel must be apparent from the conduct of the persons accompanying the principal culprit or some other clear and cogent incriminating piece of evidence. In the absence of such material, the companion or companions cannot justifiably be held guilty for every offence committed by the principal offender. Stop, next para. The liability of one person for an offence committed by another in the course of a criminal act perpetrated by several persons will arise under section 34 of the Penal Code 1860 only where such criminal act is done in furtherance of a common intention will of course be difficult to get, and such intention can only be inferred from the circumstances. But the existence of a common intention must be a necessary inference from the circumstances established in a given case. A common intention can only be inferred from the acts of the parties. Unless a common intention is established as a matter of necessary inference from the proved circumstances, the accused persons will be liable for their individual act and not for the act done by any other person. In order to bring home the charge of common intention, the prosecution has to establish by evidence, whether direct or circumstances, that there was plan or meeting of minds of all the accused persons to commit the offence for which they are charged with the aid of section 34, be it pre-arranged or on the spur of the moment, but it must necessarily be before the commission of the crime. Thus, in this case, as far as the appellant is concerned, the evidence against him essentially consists of the recovery of the mobile phone, and there is discrepancy about the number which we have noted. PW5 has not taken the name of the appellant. Essentially, evidence of PW5 and the recovery is relied on to hold that the chain of circumstances is complete. The appellant is not mentioned as one of the persons who used to visit the deceased's father, though three of the other accused were named Vizard, Viru, Kalli and Virendra. Stop. Thank you very much. Guys, there is one humble request. Please always try to repeat the matter so that your fluency and accuracy of steno can improve. And also there is one more request. Please subscribe the channel so that you can get the first notification on legal and general matter. Thank you very much.